Now, a will in today's society and here in Florida typically is prepared as part of a package of documents. If you go to see an attorney and have estate planning, future planning documents drawn up, it'll be part of a package with several other documents like a durable power of attorney, advanced directives for medical decision making, also known as a living will, those types of things. And usually you will not have to pay more than a couple $100s for a whole package worth of very important documents. And that is a tremendous value because, again, I can tell you, having been on the other side, having been in contests of documents, you can spend a whole lot of money very, very quickly. And I've seen people try to save on planning expenses and end up simply creating problems down the road, which again is part of our overarching goal here is you're trying to avoid doing that. So you can have good documents, you can have them drawn up properly that will avoid a lot of problems down the road, and you can do it relatively inexpensively. Now, as part of that package, I believe it's also very important to have a living will, advanced directives. It comes by several different names. But basically, the purpose behind those documents is for you, again, to decide what you want to have happen to you if you're not able to express yourself. So what kinds of decisions do you want to be made medically for you? If you're injured or you develop an illness or something happens to you and you can't express yourself, you can't say, this is what I want to have happen. You can execute a living will, advanced directive, and that document will then control what the process will be. You can name someone who you trust, a spouse, a child, a friend, whomever it might be, to make those decisions for you. Now, again, I think that's very important for you to be able to make those decisions and have that control over your care and over your life as much as possible. Because, again, if you don't execute that type of a document and you are in that situation and there are questions about what course to pursue, those decisions will be made. But they'll likely be made by a judge who, again, he or she may not know you, may not know your family, may not know anything about you, and all they will have to rely on are whatever is in writing, whatever people may remember from talking to you, or what you may have expressed. Now, this is the exact situation that Terry Schiave found herself in. And the problem arose there because Terry did not have a living will. She was a young, healthy woman, didn't see a need for it, but when she had the catastrophic event happen to her, she was placed in the position of, okay, I can't express my own wishes. What happens now? What happens now? What happens to her? And we all saw that play out. We'll talk about that more in just a second, but let me also say that some other important planning documents are pre-need declaration of guardian. Now, these are very useful documents, and they're often underutilized. A lot of people don't know about them, but the pre-need declaration of a guardian for yourself and for your minor children can, again, head off a lot of problems down the road. For instance, the way the pre-need declaration works, I can say, okay, look, I'm Rich LaBelle. If something happens to me and somewhere down the road I need a guardian, I want my wife to serve as my legal guardian. I sign the form, I send it to the clerk of the court in the county where I'm living, they put it on file. What happens is if someone comes along and files a guardianship action involving me somewhere down the road, the clerk goes through their files and says, oh wait, here Judge, here's a pre-need declaration of guardian that Rich LaBelle has executed. It's in the proper form, and he wants to have his wife appointed as his guardian. Under Florida law, the judge is required to follow that declaration, who you name in that declaration, unless there's some reason why under statute that person couldn't serve. For instance, like a felony conviction. Persons who have felony convictions can't serve as guardians in Florida. But if there's no other, disqualifying condition like that, the judge has to appoint that person whom you name. Now, if you don't have the pre-need declaration in place, then the judge uses his or her best judgment, their discretion in terms of judging who would be best to serve as your guardian. And there are various preferences given to various people according to their relationship to you under the statute, but it's up to the judge. With the pre-need declaration, it's up to you. And that can be very useful, both for yourself and for your minor children. If something, God forbid, were to happen to you, and you can say, okay, here, this is the person who I want to serve as guardian of my children. Same process, works the same way, and again, it gives you more control and potentially eliminates a lot of problems down the road. And that's what you're trying to do. Now, the last document that I want to talk about with the general package that you'll get through most planners these days is a durable power of attorney. Durable power of attorney is a very, very useful document. But it is a very powerful document as well, and you need to be careful about how you treat it and who you give your power of attorney to. Because what happens is with a power of attorney, you are saying legally, this person who I name has authority to do all sorts of things with my property just as if they were with me. So, with many powers of attorney, you can say, okay, this person has authority to sign deeds to sell my property, to go in and access my bank accounts, to do all this other sort of stuff on my behalf, just as if they were me. Well, again, that can be very useful if, for instance, you were not able to do those things yourself. You wouldn't have to take the step of having a guardian appointed for you to have that legal power to do those things. You can voluntarily say, while you're of sound mind and body, okay, this is the person who I want to be able to do these things for me, and I voluntarily give them that power. But again, you need to be careful, because the person whom you give that to needs to be trustworthy beyond question. Because with that document, yes, you're able to do a whole lot of things, just as if they were you. So typically this is done between spouses. Many times it's done between parents and children, but it's a very useful document. It can avoid guardianship in many cases, but you need to be careful with it as well. Now, let me turn back just a second to the issues of living wills and advance directives. Again, as I said, I think it's best for people to be able to decide what you want to have happen to you, instead of it ending up somewhere in a contested proceeding in front of a judge who may not know anything about you or your family. When I was practicing and still talking to a lot of families, a lot of people will come to me and say, if I am in that condition, or if I am like that, I want my family to just pull the plug. Well, living like that or that condition can mean a lot of different things for different people. But the thing that I find most remarkable is that it very, very seldom, those types of decisions come down to just pulling the plug, as it were. It's not as simple as just disconnecting a respirator. With the vast, vast majority of cases, making decisions to withdraw care, to terminate someone's life, if that's the decision that they truly would not like to continue to live in whatever condition they may be in, it involves withdrawing medication many times, it involves withdrawing food and water, and that's not a pleasant process.